My name is David Murakami Wood. I'm from Queen's University in Ontario, and I'll be chairing this session. I also had the good fortune, and the reason why I'm chairing this panel, to be a visiting fellow at the Center for Business Information Ethics at Meiji University, although not actually at that center, but with Murata Sensei and Professor Adams here. So I'm very pleased to be chairing this session this morning on the reform of data protection in Japan. My job as chair is very simple. I'm going to do very little and just make sure the session finishes on time. So without further ado, I'll hand over to Professor Murata, who will introduce you to our distinguished panel this morning. Thank you. Murata Sensei.
Thank you very much. Good morning. So I'm Kiyoshi Murata from Meiji University, the moderator of the panel. So first of all, let me introduce the chair and the panelists of this panel. Dr. David Murakami, sitting opposite side. The chair of this panel is the Canada Research Chair in Surveillance Studies and Associate Professor in the Department of Sociology, Queen's University in Ontario. He is a co-founder and editor-in-chief of the journal Surveillance and Society. Here after the panelists, next to David, Andre Adams is Professor of Information Ethics at the Graduate School of Business Administration and Deputy Director of the Center for Business Information Ethics at Meiji University in Tokyo. He has a doctorate in computer science and a master's degree in law. He has published research on privacy, surveillance, copyright, health informatics, sex and technology, and other things. Kazue Sako is a senior engineer at NEC. She received her PhD from Kyoto University. Her research interest is in cryptographic protocols that enhance privacy and fairness, including electronic voting protocols, group signature schemes, and digital lottery systems. She is a member of ISO/IEC Information Security Technology Subcommittee and working in identity management and privacy. She is a strong advocate of personal data ecosystem, which empowers individuals with their own data. Dr. Fumio Shimpo is professor of the Faculty of Policy Management, Keio University. He has served as a committee member of several councils within the government of Japan, as a specialist in privacy and information security, and also as director of the Institutional Law Society in Japan, director of the Law and Computer Society of Japan, senior research fellow at the Institute for Information and Communication Policy of Ministry of Internal Affairs and Communications. He has been responsible as a vice chair and Japanese delegate for the OECD Working Party on Security and Privacy in the Digital Economy. Kaori Ishii is Associate Professor at Faculty of Library Information and Media Science, University of Tsukuba, Japan. She received her PhD in law from Chuo University after having engaged in practice as an attorney at law. Her strong research interest is in the field of protecting privacy and personal data. She had served a member at many governmental experts committee in Japan. So before beginning the talks provided by the panelists, I'd like to provide a brief explanation about the background and purpose of the panel. By the mid-90s, ICT was recognized as a strong strategic choice to maintain Japan's international competitive strength. The Advanced Information and Telecommunication Society Promotion Headquarters was established in 1994, and its successor, the Information and Communication Technology Strategy Headquarters, was set up within the cabinet in 2000, and the basic act on the formation of an advanced information and telecommunications network society was established in the same year to realize the IT revolution, restructuring of industries and society in Japan by using ICT. The stated purpose of these organizations was to develop a policy environment in which all Japanese could share the benefits of ICT and to make Japan the most advanced nation in ICT. In such a situation, the fact of utilization of personal data by commercial organizations was re-acknowledged, and the introduction of JUKINET, the national computerization of the local register of citizens, enabled by 1999 legislation and starting operation in 2003, created the social need for personal data protection legislation suitable to the ICT environment at the time. Finally, Japan's public sector only personal data protection laws from the 80s were expanded to cover the private sector in 2005. However, the 2005 laws and the relevant guidelines and ordinances seem not effective to protect the right to privacy of the Japanese. They have allegedly provoked excessive responses among organizations and individuals, which have been an obstacle to necessary and useful personal data use and flow or sharing, causing government-led depression or compliance depression on the one hand, but at the same time, personal data leakage incidents, including 1.25 million personal data leakage from the National Pension Agency, and about 30 million personal data leak from Benesse Corporation, detected in June 2015, have continually happened. In the current ICT environment in Japan, where big data and the Internet of Things have gathered great attention, and the My Number system, the Japanese new citizen numbering system, has launched, the subject of this panel is worthy to be considered from the diverse and multidisciplinary viewpoints. Okay, so now the time to starting the speech from the panelists. The first speaker is Andrew Adams. Based on his work in the Japanese sense of information privacy and the development of Japanese data protection papers, he will discuss the social and socio-political background of the 2005 laws and the recent revision, and also mention media coverage of issues like the Benesse case and his more interested investigations in the attitude to privacy and data protection law in Japan in numerous research projects he has been engaged in. So, Andrew?
Thank you very much. Thank you, David, for chairing the panel for us. So I'm going to give you some context about Japanese people's attitudes to information privacy. I see we have a few Japanese people in the audience, so please forgive me if some of the nuances is wrong here, but I have been studying this in Japan for quite a long time, and I think we have a good handle on this. And this work has been developed with Murata Sensei and a colleague of ours, Dr. Orito, from Ehime University. I'll then also give some context to what's been going on in these last 10 years, a bit more detail than Murata Sensei has been talking about why the attitude now is that data protection really isn't working even as well as people who wanted weak data protection in Japan wanted back a decade ago, and why we've had not just a new act, but also the process will be ongoing, because that new act is partly an enabling act and is intended to support further regulation going forward. Is that not going? Okay. So I'll talk quickly about the pressures on Japan to introduce global full sector data protection, which starts really in the late 90s.
You want to show the slides up there?
Ah. Oh, we've not got that.
Where's this? Slides not working.
Sorry about that minor technical. Yes. So I'll talk about the pressures on Japan to introduce data protection in the late 90s. I'll talk about both the public story, the very visible one about why the 2003 law, which came into force in 2005, was passed, and why the details of it, as it were. But I'll then talk about the hidden agenda that we identified and published in our paper, the development of Japanese data protection, and talk about the general social context of Japanese people's attitudes to privacy, information privacy in particular, by presenting a variant of a well-known model of Japanese social interaction called the Uchisoto model. I want to stress when I get to that one that this isn't a model which is unique to Japan. It's simply a very precise model about how Japanese people think. It's very similar to how social interaction operates elsewhere, but the details are very precise in Japan, and Japanese people have very clear ideas of the boundaries and how things work. So if you can bring the next slide up, David. Thank you. So up until the mid-90s, the processing of personal data in Japan was actually very limited. And this is due to the fact that personal data primarily includes kanji characters, the Chinese-derived characters in which Japanese is primarily written. Now, you can write Japanese in purely phonetic forms, and that's what was being used through the 70s and 80s in Japan. And in fact, there are still historical institutional effects from that. So, for instance, bank accounts are still primarily written in purely phonetic formats. And in fact, in particular, encoding, and it causes some issues with online banking in Japan, that you have to enter what's called half-byte characters in the web page, and sometimes you have to use a virtual keyboard in order to get that into the web browser. But in the mid-90s, they finally sorted out an efficient way of both encoding and displaying kanji characters, but in particular, an efficient way for people to enter them into databases, and for that to become a common encoding standard that could be passed amongst companies. Now, at the same time, this was during the depths of the recession caused by the economic bubble bursting at the early 90s, and there was a severe pressure both on government finances and on large corporations. So these pressures on the government finances, these pressures on commercial companies, changed the relationship between individuals in and companies in Japan. One of the obvious examples of that was the shift away from permanent employment in many companies. In Japan, it was very, very rare for large companies to lay anybody off. And yet in the mid-90s, they started laying off significant numbers of staff due to their economic pressures. And this was partly as well due to, finally, globalization penetrating the Japanese economy. And this is basically 100 years after the formal lifting of the isolation. The Japanese economy internally had to start facing up to the issues of globalization and international practices. And so companies started adopting, in some areas, a much more international attitude, and that included the attitude from elsewhere, particularly America, on how you process personal data. And people started to see, it took a few years before people started to see the implications of this, and there was growing concern amongst the populace in Japan that their data was being used and that there were no regulations on this, and it seemed like that their rights were being violated, their expectations were being violated. Next slide, please. So the public story behind the development of JukiNet and the data protection law passed in 2003 is that this local-based citizen registration system called the Juminhyo system was proposed in 1997, 98, that it would be developed into a national computerized system, and they passed enabling legislation for that in 1999. And there was a public and mass media campaign against this idea running through 2000, and in particular there were concerns which had been raised by both government and commercial processing of people's personal data. You have to realize the Japanese civil society is very weak, and at this point was even weaker. And these sorts of mass campaigns were very unusual in Japan. So the government was quite concerned about this, and so in 2001 they promised to update the existing 1988 legislation covering the public sector before JukiNet came into operation. The media then started saying, in response to overt public demand, well, okay, that's going to cover the JukiNet case, but we've still got concerns about how businesses are using personal information. This seems to be unrestricted and not to the benefit of the citizens. So the media campaign raised the question of, well, what about the commercial issue? Why is there no regulation at all in Japan on regulating commercial use of personal data? And then, interestingly, in 2002, Keidanren, the large Japanese commercial sector lobby group, was against the idea of commercial data regulation, commercial data processing regulation in Japan. But they actually did a flip-flop. They flipped round, and in 2003, they changed and they issued both overt and private advice to the government that they would be in favour of a development into a system which might approach data export adequacy for the EU. And basically this seems to have been because Japanese companies at this point were beginning to get involved in data transfers with the EU and were finding it quite onerous to meet the Data Protection Directive requirements on that. And this, remember as well, is at the same time that the US had recently concluded the Safe Harbour Agreement, because previous to the Safe Harbour Agreement, Japanese companies were very concerned that any regulation in Japan might affect their trade with the US. But with the US having a system whereby they could trade with Europe and pass data back and forth reasonably freely, the Japanese felt that, well, maybe we can have a similar agreement with them and that this won't severely harm our American trade, but we can start building up our European trade more. In 2002, the legislation enabling JukiNet as a whole was passed before the DPA law update, which violated the government's promise, not unusual in Japan, but they did then pass the Data Protection Act in 2003. By 2015, this had led to, well, not a lot. As Murata Sensei said in his introduction, there was a lot of regulatory hangover and a lot of issues where people were being told, oh no, we can't possibly give you your data because data protection law prevents us giving it to you. The sort of thing we've seen everywhere where they've introduced new data protection regulation for the first time. Companies don't know what they're doing with it. They use it as an excuse to not do things they don't want to do, and they make mistakes on what it does and does not allow them to do. Particularly, they make mistakes on whether consent gives them all the rights to do anything, or the lack of consent gives them no rights to do anything. But the big issue there is that the enforcement was based on ministerial oversight. And ministries are supposed to issue a letter to any organisation, much in many ways the FTC model, that when an organisation violates data protection, the minister issues a letter telling them what they've done wrong and what they must not do in the future and what they must do in the future. And in 10 years of being enforced, no single letter has been issued, despite regular data breaches, data misuse, and complaints from members of the public. So next slide. Now, the hidden agenda behind this is that the Japanese bureaucracy has always wanted to be heavily controlling the population. And so there is a hidden agenda behind JukiNet, and it's all to do with control and taxation. And so what we see is that the restrictions placed on the government for use of data in the 2003 law, which covers the public sector, was seen as overly restrictive to this dream of a bureaucratic surveillance state. And this is one of the things that leads us eventually to the 2015 law. Now, in an interesting switch, the 2003 Act, when it's translated into English, is reasonably well translated as Act on the Protection of Personal Information. The translation of the 2015 Act is, and I'm trying to remember the exact wording, it is something like the Act on the Promotion of Personal Data Usage. It's clearly a different agenda going on behind the scenes there. So move on to the next slide. So that's the legal and political situation. But before my colleagues start talking about some other aspects of this, and Shimpo Sensei gets into the detail of this recent act, I just want to give you a bit of background on the Japanese social setting of privacy. Now, this is a well-known model of social interaction in Japanese, and as I say, it can be applied to many cultural settings. But this is a very precise model that most Japanese, even subconsciously, it's not innate, but it is something that develops in them throughout childhood and throughout early adulthood, to the extent that they innately understand where people are on this model. Now, historically, the tannin, this outside group, which is the other, were not of concern to the Japanese in terms of information processing, because these were people you never interacted with directly. You might interact with them once. There'd be a traveller walking through your village, and you didn't care what they knew because it had no comeback on you. The group that was concerned was the Soto group, which is those who are outside your core grouping, from which you have weak social ties. So you have very few abilities to control what they do, but with whom you have a regular ongoing relationship. And they are the people with whom you have a concern about what they'll do. So in the modern era, what we have is that when you're working with your bank or with any other organisation as an individual, they are a Soto group. You have regular dealings with them. That can have a negative impact on you, but you have a one-to-one relationship with them. And until the mid-90s, that was mostly how the personal processing was done in Japan. It was with people in the Soto group. And there's well understood social mechanisms as to how that would work. But then with networking and the interoperability of personal data that came through in the mid-90s, suddenly the tannin, groups with which you have no regular direct connection, start being able to process data about you. And this concerned the Japanese, and this is where much of the concern that led to the 2003 law came from. Next slide, please, David. So the Japanese sense of information privacy, and that's the title of the paper. If you want more details, I encourage you to read that. It's based on confidence in both of its meanings. People expect something told to a group, certainly in the Uchi group, but also in the Soto group, to be treated with a level of confidence. And they expect to have confidence in those dealings. But the trouble is that confidence does not exist in either form for the tannin group, who now have access to people's data. Privacy was traditionally provided by what's called tatamaya, which is sales talk. And that's particularly with the Soto group. You say things which everybody accepts. They know they're not accurate. Within the Uchi groups, there is this as-if tradition. You act as if you don't know information you have if it's not socially acceptable for you to have that. But this was severely undermined by the introduction of network computer processing in the 90s. And following a similar model to what we saw in Western Europe and the United States and Canada, this first people are concerned about their financial information, their credit card numbers, their bank account details, then their medical information becomes of concern. And then they finally realize that all of this matters. And that's the development we've seen from the late 90s up until the present day in Japan. What our recent work on the empirical studies of Japanese attitudes to privacy has shown is that there is a trust in government protection, that people believe the government are protecting them, are trying to protect them. But when that fails, there is a feeling of powerlessness. Japanese people don't know what to do because they have no mechanisms, because these ministerial letters are not working. There is no individual right of complaint or appeal. And there is a significant democratic deficit in Japan, and that's driving a problem with this. Now, the 2015 revisions, which Shimpo Sensei will talk about in a moment, my evaluation of those is that they are rather half-hearted, they are unfinished. Some of it is enabling legislation that might finish it if we get it right. But the big problem over the last couple of years as they've been discussing this is that there's both industrial incoherence. Japanese industry is not speaking with one voice. Keidanren is saying we need EU adequacy. But individual companies within Keidanren are saying, no, we don't want heavy regulation. The light touch is all that's needed. There's also a significant expertise deficit in government, notwithstanding the very good work done by my colleagues on this panel. The general bureaucrats in Japan are very, very underskilled in this area, and that's showing in the detailed implementation and the understanding of things like what anonymization is in the new law. So, thank you very much.
Thank you. Thank you, Andrew. So the next speaker is Kazue Sako. From the viewpoint of the business person who has engaged in the development and implementation of cryptographic protocol, she will talk about the vision of the personal data ecosystem where rich personal data are used to benefit individuals as well as society in a correct way, technological approaches towards it, and the challenges referring to the Kiyoshi project she engaged in. Next.
Okay, thank you for the introduction, and thank you for having me here. And I was excited to hear Andrew's presentation. I'm not sure how it fits with my presentation, but let's see. Okay, okay. So because I was given an introduction, I might not need to go through this, but again, my background is cryptography, and I've been working on a lot of privacy-enhancing technology like voting systems and anonymous authentication systems. And you can see in the picture, we even implemented a chip that accelerates this anonymous authentication or group signature schemes that enhances privacy. But unfortunately, after 5 years, this has not been launched. But perhaps in the age of IoT, maybe this would come alive, hopefully. Okay, so I was talking about voting system over the past few years, and it seems there is a different view according to which region I'm in. And currently, we are in Europe. And when I talk about voting systems here, yes, people do care about privacy. How is our vote privacy is maintained in my system? What about if I go to US? They care about correctness of the tally. Is the output that the computer says, is it a correct one? Can we trust on that output? So it's a different view, privacy and correctness. So what about in Japan? Can you guess what is the concern in Japan? In Asia or in Japan, they care about the cost. How much cost can we eliminate by having my voting system? So that's a very three different view over the continent. But I must say, it's not that Japanese people do not care about correctness nor privacy. It's, as Andrew said, we already have a trust, or what did you say, confidence, right? That the things that proceeded in the computer will be good enough for the correctness, and they will not misuse the privacy, so they care about the cost. So this will be my repetition, but it seems in Japan people trust government and large companies also. And as Andrew said, there are some misuses, but that was like accidental, and they were not intentional, is I think what people think. So they will try to handle, and they will do not intentionally misuse. That's what we believe in. And what about the companies? So given those situations, the companies, I think it's like Uchi, right? They try to meet the expectation of these individuals. So, and they're afraid of losing reputation. So, and also what law says, we are not sure technically what does it mean in the computers. So the companies really try to do more than what the law says in order to not to make the individuals angry. So now I'm coming back to the personal data, not voting system, but personal data. And what does that mean? So the companies want to take good care of their personal data of their customers. So, and they don't want to misuse it. So what happens is that they're going to spend a lot of money in order to maintain these personal data to be secure. But they will not use it because they are afraid of people getting angry. So it's locked dead in their silos, in their computers. Okay. So what I repeat is that because these personal data, which has this potential of giving benefits to the individuals and to the society, is locked in the computer rooms of these companies. It's like we have it in the upper left-hand corner. But instead, if we return these data to the individuals, and if they control their own data, they could have they could have a lot of their data from like telcos or like transportation logs and retail logs, and they have all this location data, purchase data that they can use for their own benefit. Maybe I should be spending too much on this thing, and I should be doing much more of savings. Those kind of things can be done using, if I have all my data in my hand. And moreover, if they could decide how they want to use the data, then they would be willing to give their personal data. Let's say this person would be willing to give their data in order to plan a city for a better transportation. Maybe he is happy to give this personal data to those people who would use it and whom you trust. So that they would put their policy to their data and will be willing to give these data. And perhaps they get some money out of this data. They would give it to the companies. Okay. So this idea is not Japan only is considering, but we heard on the Wednesday afternoon, like Digime, and there is a lot of project all over the world, like Maison. I'm sorry for the typo there, but there is Maison-Fort in France that also considers this architecture, and Respect Network in Silicon Valley, and My Data project in UK also is a part of this idea. OpenPDS in MIT, and the list goes on and on. And perhaps I will take some more minutes to discuss 3 projects in Japan. One is called Information Bank Consortium. This is run by Tokyo University. And like, if you have all your data, like your money, you will not be handled all your money by yourself, but you give it to bank so that they would manage your money instead of on your behalf. So the same thing might happen with the data. If you all you have your data, you want to designate to someone you can trust, and that's the notion of information bank. And the recent scenario we are thinking in this information bank consortium is that perhaps the mountain climber, Google Maps might not have a good location over where everything is in mountains, because you can't run a Google car there. So maybe if the climbers themselves carry some device that tells you where their location is, that might be useful in many purposes. Like the family who's waiting for their husband or father to come back, they can be assured where your husband is. And this data can be used by a service provider to give more tourist information and not to go this place. And all this data ecosystem can begin with all these personal data. And I'm sure this climber would be happy to give those personal information. Okay, and then the second project I wanted to talk about is called the Distributed Big Data Consortium. And this Japanese name is called Non-Collecting or Uncollecting Big Data Consortium, because it's not the companies who's collecting our data, it's going to be collected by us. And we were thinking about how our personal data store can be organized and can be made into standardization. And this group is now became a bigger group in COCN, which stands for Council on Competitiveness Nippon. And you can see all the big names here is considering this scenario and see how a business might fly based on this idea. And I think that's all I need to say. There is a tremendous challenges on what to do, like does it mean by that one manages their data, or what does it mean by data ownership, and what is a good, well, technically speaking, what is a good set of permissions or actions on data, and how should the semantics be, and how should the global standardization should be, because as I said, this idea is being driven from different parts of the world, and I think this needs to be a global standard, and again, open standard so everyone can use. And I think that's all I have to say. Thanks.
Thank you very much. So the next speaker is Fumio Shimpo. Based on his experiences of committing the development and the revision of the Japanese Personal Information Protection Act, he will explain the notable points of the revision of the Japanese Personal Protection Act, which was passed in September last year.
On the textbook there is a presentation file. Yes.
Thank you. Okay.
Thank you. I'm Dr. Fumio Shimpo, professor at Keio University. I'm going to talk to you about the current Japanese data protection legal system and the revised Japanese Personal Information Protection Act of 2015. Nevertheless, most serious issue regarding the Japanese data protection situation until now is that the low level of interest in the Japanese data protection legal system at the international community. As you see, there are many participants of this session. Therefore, I think I have served as a member of the Law Reform Committee of the Japanese Personal Information Protection Act. Therefore, I recognize that the most important role for me is to promote the understanding of the Japanese data protection legal system. So let's start my presentation. The Japanese data protection law legislative structure is based on three main laws related to the protection of personal information protection law enacted on May 30th, 2003. And there are public and both public. This law covers both public and private sectors. And also there is law regarding administrative organs, and independent administrative agencies, covers both public sector. And these acts are supplemented by ancillary legislation and administrative documents. Please refer to this PowerPoint slide sheet, overall outline of personal data protection laws in Japan. This slide is display information concerning the current Japanese data protection scheme. The basic policy is a cabinet order on the enforcement of the Act on the Protection of Personal Information, sets out enforcement guidelines, and sets out of the basic direction and basic matters to be taken by the state, local, and public bodies, independent administrative agencies, and entities handling personal information. Existing laws and regulations, for example, employment security laws, Unfair Competition Prevention Act, National Public Service Act, and other professional laws also provides data protection regulations. Japan is a unitary state, not a federation, but data protection ordinance passed by 1,742 local government bodies are a significant complex part of the legal system. Local governments had issued personal data ordinance in Japan since the early 1970s, and from the early 1980s, the OECD privacy guidelines became the model for local government regulations. All current local governments had enacted data protection ordinance. The current Japanese data protection law is ministry-based, which each ministry supposedly enforcing the act. Guidelines are also have an important role for data protection legal system in Japan. And next slide is regarding the jurisdiction of competent ministers. Most important in practice are the guidelines set by each ministry, of which over 40 guidelines have been established in 27 fields. The fields cover quite specific industry subsectors. Ministry-based enforcement structure is very complicated to understand the structure and the enforcement of the Japanese data protection law. Each competent minister has a right to enforce a law based on these guidelines. The consideration for law reform of the Japanese data protection law started from September 2013. This year marks the 10th year since the enactment of the Act on the Protection of Personal Information, and during this decade, there has been considerable progress in information and communication technology that now makes it possible to collect and analyze large quantity of that diverse data, like big data. These new abilities are expected to contribute to Japanese innovation by creating new business and services and by helping to solve many of the issues that the country confronts. There have also been significant changes in the social context of personal information and privacy. The concepts of personal information and privacy are broadly recognized within society, and there is greater awareness of privacy among consumers, but there are also cases in which business come under social criticism for their processing and controlling of personal information, even though they are in compliance with the duties stipulated in the Act on the Protection of Personal Information. There are also opinions that in many cases, businesses hesitate to make use of personal data because of the ambiguity in the rules for its usage. So therefore, the Japanese government released a direction on the institutional revision for personal protection and utilization of personal data. This direction was published on the 20th of December 2003. The direction indicates a basic framework for the revision of the current personal information protection law. The direction constitutes from three main parts. One, background and purpose. Two, direction for the review. And three, issues to be addressed. The Japanese government's growth strategy lists the utilization of data as a means of economic growth by improving the utilization of personal data, while the practice to prevent the violation of individual rights and interests and to ensure the protection of personal data and privacy is necessary to create an environment to enable both the creation of new industries and services and the security and protecting individual rights. Furthermore, globalization of corporate activities, advancement in ICT, such as cloud services, promote cross-border data transfer. In order to consider such changes, the OECD amended its privacy guidelines in September 2013. Then the Japanese government was the first country to decide to amend the personal information protection law inconsistent with the amended OECD guidelines and implemented its revised provision. And next is the outline of the revised law. Then the Japanese government released the details of its proposal for amending the current law in June 2014 as the outline of legislative bill on the institutional revision for utilization of personal data. And the outlined provisional revised draft bill was published on 19th December 2014. On the 10th March 2015, the bill was endorsed by the cabinet, and this bill was finally submitted to the National Diet on the 20th April 2015 and enacted on the 3rd September 2015. This act was promulgated on 9th September 2015 but had not yet been enforced. Then next, I'd like to explain the following major point of the revised Japanese Personal Information Protection Act. The first major point of the revision regarding this law focuses on the clarification of the definition of personal information. Regarding the definition of the term, personal information was clarified to indicate information about a living individual that contains any text, number, code, or any other symbol. The revised law provides two additional definitions regarding the term personal information. The first additional definition is a symbol created by converting a feature of a part of the body of a specific identifiable individual for use in a computer and which can identify that specific individual. For example, fingerprint data, face recognition data and stuff like that, or the various form of identifier. Then the second one is a symbol assigned in relation to the use of services provided to a specific individual or the purchase of products sold to an individual or affixed to documents issued to a specific individual and which is assigned or affixed as a different code identifier for each such user, purchaser, or recipient. For example, passport number and driver's license number. The background of this amendment relies on vagueness of legal interpretation of the scope of personal information and vagueness of the rules that govern business operators regarding the scope of protection and its handling, where the personal data does not identify individual as is but has a high probability of identifying individual with some process which then can violate individual rights and interests. Then one of the purpose of revision of law is the improvement of the utilization of personal data, mainly with respect to the handling of big data. Therefore, the revised law provides for the development of provisions for ensuring the usefulness of personal information under appropriate regulations. The first feature of the promotion for use of personal data is to provide a new definition regarding the development of provision concerning anonymous processed information. The new concept of anonymous process information, API, is defined as information related to an individual that was obtained by processing personal information such that a specific individual cannot be identified and so that such personal information cannot be restored. Upon creating anonymous API to be provided to a third party, the creation of such information must be followed the rules provided by the Personal Information Protection Commission. The personal information must be processed so as it cannot be restored in accordance with the standards set forth in the Personal Information Protection Commission rules, such as by deleting description which can identify a specific individual from the personal information. In addition, business operator which create API must additionally take necessary and appropriate measures for preventing the divergence of information related to the deleted description and processing method. When business operator which create API based on above mentioned method will provide such an API to a third party, a business operator must publicly announce the provision of such information to a third party and then clearly indicate to the recipient that the provided personal information is API. Personal data utilization is expected to create innovation and new businesses through cross-industrial utilization of a large amount of diversified data. However, the current framework based on the current law requires individual consent before the data can be used for other than the intended purpose or the data can be provided to third parties, with the understanding of the intent of current act that individual consent is required to prevent the violation of individual rights and interests. A new framework which under the newly created rules enable the provision of personal data to a third party without the individual consent as handling API. The revised act also provides that the next part related to the development of provision for enforcing and reinforcing the protection of personal information. The revised act also provides a new definition regarding sensitive information with regard to personal information which contains description, for example, person's race, religion, social status, medical history, history as a crime victim, criminal record, or personal history. That requires special consideration in the handling thereof so that the person will not be subject to unfair discrimination or prejudice. The acquisition of such personal information without obtaining the consent of the person shall be prohibited as a general rule, and shall be excluded from the alleviation of restriction on the purpose of use and the special treatment in the case of providing personal information to a third party without obtaining the consent of the person. Furthermore, the revised act provides 3 additional obligations regarding the third-party offering of personal information. The first is traceability, and the second is the crime of providing a personal information database for the purpose of seeking unjust profit, and the third is the notification of obligation, the notification to the Personal Information Protection Commission by reviewing the opt-out procedure. And the other provision is, for example, dealing with SME, small and medium-sized enterprises. This means that deletes the current provision which excludes a business operator which handles small amount of personal information from the definition of business operator handling personal information. This means that SME exclusion will be deleted, and add obligation of business operator handling personal information to make efforts to delete personal information. And clarification of right of request means that by clarifying data subject of the personal information has the right to request the disclosure, correction, and discontinuation of the use of personal data to the business operator handling personal information. The most important aspect of this law reform is to establish the new supervisory authority. The name of the new authority is the Personal Information Protection Commission. Japan did not have any supervisory authority, so therefore the establishment of this new authority is a very important turning point for the Japanese data protection legal system, for cross-border cooperation, for interoperability with respect to keeping the free flow of information. The specific Personal Information Protection Commission was established solely to regulate Japan's new ID number system. The government of Japan started assigning the social welfare and taxation number. This national ID is a unique 12-digit numbers assigned to each resident in October 2015. The government had sent out the number notice to all citizens. The revised Personal Information Protection Act incorporated this specific DPA into a new general DPA. The Personal Information Protection Commission has jurisdiction in relation to the whole private sector. On the 1st of January 2016, this commission is replaced to the Personal Information Protection Commission, and the new commission supervises the protection of personal information comprehensively in the private sector, in addition to the current specific Personal Information Protection Commission authorities. The Commission has strong provisions concerning its independence. The Commission consists of Chairperson Professor Horibe and 8 commissioners appointed with the consent of both houses of the National Diet. The Commission is one of the highest independent organs in the Japanese legal framework, sets rules about personal information protection and cooperate with other entities in foreign jurisdictions. The last point of this law reform relates to the development of provisions for dealing with the globalization of the handling of personal information. The revised act provides 3 new provisions. The first is cross-border enforcement. The second is cooperation between foreign law enforcement authorities. And the third is data transfer limitation. This act applies to cases when the business operator handling personal information acquired personal information of the person located in Japan through the provision of products or services to that person handle such personal information in a foreign country, excluding countries related to orders issued by the Personal Information Protection Commission. And the next is the Personal Information Protection Commission shall be able to provide to foreign law enforcement authorities that enforce foreign laws corresponding to this act information which is considered to contribute to the execution of their duties. And the last is when a business operator handling personal information is to provide personal data to a third party located in a foreign country, that business operator handling personal information must obtain the consent of the person regarding the provision of such personal data or compliant to security standards provided by the Commission. This is the end of my presentation. Thank you very much.
Thank you. So the last speaker is the Kaori Ishii. As a legal researcher in the field of personal data and privacy protection, she will illustrate the aims and expected effects of the revision of the Personal Information Protection Act and the Unfair Competition Prevention Act, referring to actually occurred personal data leak incidents, and of the National ID or My Number Act, which was recently set up.
My name is Kaori Ishii. I am an associate professor at the University of Tsukuba. Thank you for giving me a great opportunity to be here. I will make some comments on Professor Shimpo's presentation from my personal point of view. The first I will talk about is regarding the amendment of the Personal Information Protection Act. The second relates to the new legal provisions for reducing inappropriate disclosures of personal data triggered by the Benesse breach case. Linked to this issue is the passing of the Unfair Competition Prevention Act, which also was amended to address illegal data transactions. The third is the amendment of the so-called National ID Act in Japan regarding the National Pensions Agency breach case. The above case triggered a data breach notification obligation to the Personal Information Protection Commission. As Professor Shimpo has explained, the PIPA was amended in September 2015. These are the main points of the amendment. I will not go into the details, but I would like to emphasize significant progress made by the establishment of the Personal Information Protection Commission. The PIPC began its work during this month. Its authority has expanded from the supervision of the processing of personal information tied to one's governmental ID numbers issued to the supervision of processing of any and all personal information in the private sector. Our biggest issue to be addressed has long been the absence of independent supervisory authority in the PIPA. I have a great expectation that the PIPC will be able to formally join in international discussions. These are the enforcement authorities vested in the PIPC. The notable one is the on-site inspections. In my opinion, the background issues of these laws, such as public attitudes toward adhering to the law, differs among countries. Therefore, the scope and the strength of the enforcement authorities should be linked to the specific situations in these countries. Regarding this, the Japanese companies are very keen to meet their legal obligations so as not to be criticized by the public. I believe that these authorities, including the on-site inspections, will reflect the progress made for ensuring effective data protection. As for the second point, the Benesse Corporation data breach case, This has influenced the 2015 amendment of the PIPA. In July 2014, a large educational company, Benesse Corporation, leaked roughly 30 million pieces of customer data. A system engineer who had been working for a subcontracted company stole the data with using his latest smartphone and sold it to data brokers. The suspect is under indictment for violating the Unfair Competition Prevention Act. The act prohibits the illegal obtaining and selling of trade secrets. Customer data are defined as trade secrets when these data are useful in commercial activities, are kept secret, and are not publicly known. The reason why the perpetrator wasn't charged under the regulations of the PIPA was that the act didn't have criminal sanctions against a person such as the one in this case. The Japanese government realized the shortcoming of the PIPA and so added provisions for addressing data thefts and the illegal selling of data to data brokers. The First Amendment is to do with the criminal sanctions against perpetrators providing personal information databases for the purpose of seeking unjust profit. The penal sanction is imprisonment for not more than 1 year, or a pecuniary sanction of not more than 500,000 yen, about 3,900 euros. The second revision concerns the opt-out provision. In principle, an entity must not provide personal data to a third party without firstly obtaining the prior consent of the data subject. On the other hand, there are exceptions, including the so-called opt-out option. If an entity publishes the items prescribed in the PIPA, it can disclose personal data to third parties without prior consent. In this revision, such an entity shall notify the PIPC, and the PIPC has to make public the notified information. The aim of this is to reduce the inappropriate transactions of personal information among data brokers. The third is the obligation to confirm receipt of personal information from a third party. If an entity has a doubt about the third party when receiving personal data, this entity has to confirm the means by which the third party obtained the personal data. The aim is to avoid receiving illegally personal information from third parties. The last amendment relates to an obligation to create records when providing or receiving personal information, thus keeping track of transactions of personal information. The Benesse case has influenced also the revision of the Unfair Competition Prevention Act. The revised act was established to expand the scope to include a person who acquired and resold a trade secret with the knowledge that this trade secret's disclosure was improper. The act before the amendment was made limited the scope to those who received directly a trade secret from a person who had received it improperly. As for torts, the victimized individuals have initiated a court procedure from 2015 against Benesse, claiming damages. There have been 5 litigations between January and December 2015. A total number of plaintiffs amounts to about 10,000. The damages claimed are 5,500 yen, about 430 euro per person. The last point is related to the amendment of the so-called National ID Act in Japan. The formal name is The act on the use of numbers to identify a specific individual in the administrative procedure. The nickname of this act in Japan is the My Number Act. Currently, they are only allowed to be used in the administrative procedures in Social Security, taxation, and disaster responses. The Japan Pension Service is one of the main players handling individual numbers in the Social Security procedures. However, the JPS system has been hacked, resulting in 1.25 million pieces of personal data being leaked in June 2015. The JPS has been highly criticized by many people. The trust for the My Number system is still at risk of being eroded. Therefore, the My Number Act was revised to oblige administrative agencies to report security breaches to the PIPC. This has been enacted in order to prevent secondary harm to individuals and ensuring the enforcement activities by the PIPC. This is the Japanese version of security breach notification rule. As for data breaches, California and many other American states have enacted data breach notification acts. These acts require that entities which have leaked consumer data must notify the data subjects of these data breaches. The aim of these acts is to prevent secondary harm via the use of this leaked data. In the EU, the data protection regulation proposal provides the rules for data breach notification. The EU e-privacy directive has already prescribed a few data breach notification provisions. The Japanese laws for protecting personal information reflect a new and important era of reform, as Professor Shimpo and I have stated already. I am personally of the opinion that the Japanese legal system should be considered from a broad viewpoint, not only through the PIPA, but also through other laws, regulations, court cases, interpretations of laws, and other elements, such as public attitudes of current laws. Finally, I expect that many stakeholders in Japan should participate positively in discussions on data protection in many international conferences. Let me finish by emphasizing the need to have discussions that are enriched by the opinions of people from different backgrounds and fields of study. Thank you.
So we'll now hear finally from Murata Sensei, who will, I think, are you going to summarize, or do you want me to summarize?
but it's, before that starts,
Yeah.
I think the bell will come soon, but I believe that we have around 7 minutes for discussion.
Okay, in that case, we should move straight to discussion rather than any more summary. There's obviously a number of issues here, so I'll try and organize questions as we come through. So right straight away, well, the representative from the State Department.
Thank you very much for a very interesting panel. I had a question about the data broker industry in Japan, because my impression is that whereas in the United States we have maybe 6 or 8 large actors who are easy to collect, if you want to have a meeting with them and tell them to change their behavior, my understanding is that Japan has hundreds of small-scale data brokers, and I just wondered, where did this industry come from? Why are there so many, and who are they selling this data to?
The reason there are so many, I think, is because of this issue that Sako-san talked about, that the bigger companies in Japan didn't enter this area because they have very much a compliance attitude. So a company like NEC wouldn't go into this because it looked at it and said, we're not sure that this would be we could be compliant with the law. We're not sure exactly what the law would require in this area. So the bigger companies wouldn't go into this area. And companies like Axiom, I think, wouldn't operate in Japan because the regulatory risk would be too high. But this meant that particularly people like direct marketers who were desirous of having data brokers that they could approach would either set up their own small sidearms in this, or there were small companies set up or expanding into this area that were less concerned with the compliance culture, that were more willing to act on the edges of the law and say, well, we'll interpret the law in our favour, whereas the larger companies are more likely to interpret the law against them. They're more risk averse. The smaller companies were more willing to take that regulatory risk, and it was frankly embarrassing when the minister had to stand up after the Benesse case and say, you know, he explained that these data brokers had bought this data that was effectively sold to them by a man in the pub. I mean, that was he stood up there and said, yes, they really shouldn't have done this. I mean, that was his response. I mean, clearly some of the provisions of the new act are based on that case, but it was embarrassing that he didn't even say, it's terrible that the original act didn't cover this, and we will make sure that the revision we're already discussing will do this. He just stood up and said, you know, they really shouldn't have done that.
So does anybody else want to respond to that, or should we take another question? Any further questions from the audience? Yes.
I just want to ask one of the panelists, or perhaps Professor Shimpo and Kaori Ishii. Are you satisfied with the latest amendment to the Data Protection Act of Japan? Are they doing enough in the amendment?
How long have you got?
Well, it is a very tough question for me because I have served as a member of Law Reform Committee. So I think the most important issue is to establish the new supervisory authority competent with accreditation standard for the International Privacy Commissioners Conference. So therefore, our first, I think it is the most important issue for the current Japanese legal system. And then regarding the ministry-based enforcement issue, there were no penalty based on the current law. Even though, as you know, the Sony PlayStation Network security breach incident occurred in Japan, not only in Japan, and on the international. However, the Ministry of Economy and Trade Industry issued only the advice based on the current Japanese personal information protection law. Therefore, I think this is our concern. This was our concern, that the ministry-based enforcement, such a weakness of the enforcement of the current law. Therefore, we think it is we need to establish the enforcement power based on to establish a new supervisory authority, and at the same time to cooperate with international data protection community. I think it is very important role for the new committee.
If I can just briefly add to that, there are two things I think. The first is that I agree that the establishment of the authority is a huge step forward for Japan. Its lack of enforcement power is a huge barrier, and it's one that will require further primary legislation, and that's a problem. Everything else is down to the willingness of the new commission to do its job well, and the avoidance of capture by that new authority, by the industry, and by the still existing powerful organisations within the existing ministries, who are the ones who have prevented for enforcement to date. The new commissioner has potentially great power in setting codes, but that was there already under the existing ministries. So it very much depends on how the people who are there do their jobs, whose advice they take. The fact that they'll be dealing with people from the FTC, from the Data Protection Supervisor's Office, and the other Europeans and others is a good step forward. They need to take advice from people like the people on this panel on what needs to be done and what needs to be done in those codes, and they need enforcement. Whether that's done through the ministries or whether it's hopefully eventually transferred to the commissioner. I'm hoping that by the time the act comes into force, there might be the political will to give them the enforcement power as well. So the next 2 years are going to be very important on that. And some of the detail needs to be really tightly firmed up because some of the provisions in the Act are very, very weak and need very, very much strengthening by the new codes.
Final word to Ishii.
As for the revision of Personal Information Protection Act, I partially agree with the revision of the PIPC, but there still have some issues to be addressed. For example, the Personal Information Protection Act in the private sector, not in the private sector, but also the public sector. And I think the PIPC has to make regulations how to make de-identified processed data. That is a big problem to be addressed. I think.
Sako Sensei, do you have any final comments on from the industry perspective before we have to leave?
I think we should go to coffee.
Okay. Thank you very much, and thank you for Murata Sensei for moderating this exceptional panel, and to all our panelists for some very insightful and interesting comments. So thank all of you.
Thank you.